Legislative Act Committee. So we have Ken will be answering your questions. And please keep your mic muted. And if you have any follow-up questions, you can put them in the chat. And if we have time at the end, we'll get to your questions. And as always, we say this is general legal information, not legal advice. And if we've skipped some of your questions or rephrased them, it was because it was too specific for us to answer here. And you should reach out to your association attorney for those specific questions. I think we could start with the first question, Ken.
Sure.
Okay, so the first question we have is, I've been reading that restating the declaration and bylaws may not be necessary as long as the association honors the requirements of 6490, which is WUCIOA. What are your thoughts on this?
So you're absolutely correct that you do not need to restate any of your governing documents, bylaws, or declaration as long as you comply with the requirements of the statute. So the requirements of 6490-445, for example, relate to how the meetings are held and called for both the association and for board members. That particular part of 6490 took effect for every community in the state on January 1st of this year. And so you don't have to change your bylaws in order to use that statute as a guide for how to give notice to your members and how to call and conduct your meetings. Okay. Some communities want to change it so their bylaws and their statute don't conflict. It does become confusing if your bylaws say that you can give notice in 10 days, but the statute says it has to be 14. So all you really have to do is make sure that the things which are prohibited by your bylaws or declaration are not conducted, and things that are required by the new statute are complied with. So there are some use requirements that relate to things like electric vehicles and heat pumps and solar panels. And there are other provisions which relate to childcare and adult family homes. And it doesn't matter if your particular declaration restricts those things, the statute may allow them to take place with specific criteria. So it is important to try and figure out what parts of the statute do apply if they conflict with your document. And you can do that with or without restating the document to comply with the new statute. I think basically the last thing is you can just make a checklist of those things that you must do and those things that you can't do, and keep it with your bylaws and your declaration so that you can make sure you're complying with the new statute. And next question, Diana.
Okay. The second question is, in an association that operates under RCW 6438, if the board enters into a lawsuit, what are the requirements of the board to keep owners informed of cost expectations and details regarding the lawsuit?
So 6438 and none of the other statutes, either the Condo Act or WUCIOA, have any specific requirements about notifying owners about litigation. And the only thing that relates to cost would be whether or not it's going to impact your budget and assessments. So the type of lawsuit and the facts of the lawsuit might make a difference in terms of how you would notify owners. But it would be uncommon for owners to get any kind of special notice about a collections lawsuit being brought by the association against a delinquent owner. It might be reasonable to give the association notice about a lawsuit if the insurance company has declined coverage or declined to defend the association, because defending a lawsuit might actually have a significant financial impact on the association. So it really becomes fact specific. It should be that the board is having some discussion about the lawsuit in their board meetings, And since board meetings are open to all members, there would be some information that would be provided to the owners through that process. That doesn't mean that you discuss everything about the litigation in an open session. In other words, you would not be discussing uh, what your lawyer is advising you about how to proceed. But certainly, if you knew that there were going to be significant legal costs or settlement costs, those are things which would come up in the open session. Okay. Any kind of legal filings and motions and court documents are public records. And so owners can certainly retrieve those documents from the court, or the owners could request those documents from the association. Those are not protected records in any way under any of the statutes, even though legal opinions from the attorney would be protected records. A document that's filed with the court is already public. It's also likely that if you have a CPA audit, that there will be financial disclosure about the litigation in the CPA audit. And the audit should state whether the CPA has an opinion about whether the litigation could have an impact on the financial well-being of the community. I think that covers everything I've got in my notes.
Okay. The next question is, I've read that an association that was formed before 2018 that never opted into common interest community, WUCIOA, can wait until January 2028 to start following the new laws that WUCIOA is saying needs followed by January 2026. Is this correct?
So the short answer is no, that is not correct. There are some parts of WUCIOA which have been applicable to every community under every statute since 2018 when WUCIOA was adopted, specifically the budget and ratification of assessments provisions. There are portions related to reserve studies in WUCIOA that have been effective for all communities since 2019. And then the statute was revised recently to take specific sections which are now required to apply to every community, regardless of when you were formed. So the statute you want to read is in WUCIOA RCW 64.90.365. Section 365 lists about a dozen sections of WUCIOA that apply to every existing community, regardless of when it was formed. Okay. So the list, and I'll run through it briefly, is, it includes section 365 itself because it's what it's doing. Section 370 is the process by which an older community can choose to adopt all of WUCIOA early. Section 405, 1B and C is the process by which a board creates a budget. That's different than Section 525, which is the process by which the community ratifies a budget. Okay. So the section in 405 related to budgets applies to everybody. Effective January 1, Section 445, which is all of the procedures for holding annual meetings, holding board meetings. That's the one which everyone is all excited about because it says you need to give 2 weeks notice and you have to have open meetings and you're not allowed to do executive sessions except for very specific purposes. So if someone's telling you 445 applies to you today, the answer is yes, it does, because it applies to every community in the state. Section 480, but only subparagraph 10, which is a brand new section adopted last year, applies to all communities. And that section is the one that says that there must be a way for owners to pay their monthly dues without being charged a fee. And this is the result of management companies having fees for certain kinds of payment. So some management companies might charge a fee for processing a paper check. Some might charge a fee for an electronic transfer. And the statute basically says there has to be at least one way for an owner to pay their required dues without having a fee. The Section 502 applies to all communities effective this year, and that is the emergency provisions. So that has some exceptions to the meeting requirements that are in 445 to allow the association to respond to emergencies like fires or floods. It also allows you to deal with the pandemic type situations if the government declares a state of emergency. The kinds of states of emergency that the government might declare that would affect our communities are generally water shortages or fire risk, because those are the two which we get in this state. The pandemic would qualify as well because it was declared by the government to be a state of emergency, but I don't know why that would have actually affected most of your decision-making procedures. Section 513 deals with electric vehicle chargers. So it basically has a requirement that you allow electric vehicles within units or within assigned parking spaces with some specific criteria that the owner has to meet. We've already talked about the budget ratification process, and we've talked about Section 545, which is the reserve study section. So because 545 talks about reserve studies, it's going to sweep in some other sections like 550, which is how a reserve study is defined and how it has to be performed. Section 580 of WUCIOA is about heat pumps. And I do want to make sure people understand that that statute only requires that you must allow heat pumps inside of the unit. So if you are an HOA with land and lots, you can't prohibit heat pumps. If you're a condominium, because usually the heat pump has some equipment located on common elements or in limited common elements, there's no automatic right to have a heat pump if you're a traditional condominium of stacked apartments. So it's important to look at that, but certainly the goal of the legislature is to encourage a reduction of the carbon footprint, and heat pumps are expected to do that. And then the only other part of WUCIOA that applies to all communities is this definition section as required to interpret any of those other statutes which are listed. So if someone's telling you that you don't have to follow WUCIOA, the answer is you have to follow parts of WUCIOA. And it's not really any different than when the Condominium Act was adopted, where some sections applied to older condominiums and other sections applied only to newer condominiums. And it is, I'll say, a legislative mess that we have 4 different statutes with different provisions applying to different communities. I think that is why WUCIOA for All was passed. And so we're all sort of holding our breath for the beginning of 2028 when we can throw away the Condo Act and the Horizontal Properties Regime Act and the Homeowner Association Act, and everyone will comply with exactly the same statute. So that's all I've got on that one, Diana.
Okay. The next question is for an association that is formed under RCW 6432 and 6434. And their question is RCW 6490-410 in effect for them as an association?
Okay, so the short answer is no, because Section 410 of WUCIOA is not in the list that I just gave you out of Section 365. So Section 410 will not apply to all communities until 2028, unless the legislature makes another change during the current legislative session.
Okay. The next question is, we are currently under RCW 6432, which has no information on board of directors, qualifications. So should we then default to RCW 6434 324 for clarification?
So the qualifications for board members are typically not in the statutes. The statute only really references who can qualify as an owner to serve on the board if owners make up the board. So I guess the short answer is that I don't think any statute is going to define the qualifications for membership. WUCIOA gives the board an opportunity to remove a delinquent owner from the board of directors. And so we would normally say that you could use that same kind of provision to prohibit an owner from running for the board if they were delinquent, but you would have to have that requirement in your bylaws. You could just decide that by rule, and the statute certainly doesn't say that a delinquent owner cannot run for the board. So if you're trying to have qualifications such as they must be an owner, or they must be a resident of the community, or they must live in Washington State, or they must be at least 18 years old, all of those are provisions which you can put into your bylaws and have the membership approve them. The other part of the statute as it's written is that the board of directors is not allowed to set qualifications for new board members. Only the membership can do that. So if you want to set any kinds of qualifications, I'd certainly talk to your association attorney to see if those are reasonable and enforceable, and then make sure that your ownership as a group amends your bylaws or your declaration to set the qualifications for board members. Diana?
Next question is, if a unit is purchased jointly by a married couple, but prior to moving in, the couple separates and one party never resides in the unit, is the association required to send all notifications to the non-resident partner as long as their name remains on the title?
So the association is required to send notice to the one address designated by the board member, or excuse me, by the homeowner. So if the owner were to designate that separated partner's address as how to provide notice, that's where you would send it. If the resident is listing the person living in the unit as the person to be notified, that's where you would send it. There's no requirement to send multiple notices to multiple owners for a piece of property. The exception to that is when you start getting involved with collections activities. So, for example, the statute, which took effect at the beginning of this year, requires that you send a pre-foreclosure notice to every owner within 30 days of a missed payment. Not 30 days of when you would assess a late fee, but 30 days of when the payment was due. And that statute requires that you send it to the address requested by the owner, which might be offsite, but also send the pre-foreclosure notice to the unit itself. So if you're dealing with a person who's using a PO box or a out-of-state address for notice, you would have to send 2 pre-foreclosure notices in order to comply with the statute. There are also a couple other provisions. If you're dealing with a foreclosure action, I believe you're required to also send a notice of foreclosure summons and complaint to the unit, in addition to sending it to the owner that you have an address on record for. Diana?
Okay, the next question is a bit of a longer one. This person sent a list of decisions, and they're curious about what to do with them, but I'll start with the question and then go through the list. But the question is, where do these types of decisions get recorded, and what is the difference between them? When do you expect to use each, and should each item be supported by appropriate CC&Rs or bylaws. We understand the hierarchy of federal, state, CC&Rs, bylaws, rules, and regulations. We are not sure how these other processes fit within those structures and how they should be recorded. We assume that board protocols regarding how the board members work together could be changed by future boards, but would require a shared review and acceptance by board members. So the list of decisions or documents that they are wondering about. First is a motion, second is resolution, third protocol, policy, procedure, and last rules and regulations.
Okay, so this starts to be, I'll say, somewhat technical, and in a way that for most of our clients is not going to be particularly relevant, but we do have some that really care about details. So there is a priority in terms of legal binding authority, and they do start with laws. So federal laws take precedence over state laws. State laws take precedence over city laws. Those all take precedence over the recorded CC&Rs or condo declaration. Then you've got articles of incorporation and bylaws, which support the articles of incorporation. And then rules and regulations are used to clarify the provisions in the CC&Rs and in the bylaws. So something in rules and regulations cannot conflict with what's in the CC&Rs or recorded documents, but they can help explain or clarify. So the first two on the list were motions and resolutions. So a motion is an attempt to have the board or the community make a decision. So a resolution is a decision that has actually been made. So if you had a motion to adopt a budget, it can be made at a board meeting and it gets voted on. Once it is approved by the board, it becomes a resolution. So there are some older documents which talk about a book of resolutions and how you're supposed to keep track from the beginning of time to current day of all the resolutions which have been made by the board of directors or by the association. In practice, we almost never see that. What we see instead is resolutions reflected in board meeting minutes. And it usually will be a motion is stated, and then the vote on how the motion turned out is stated. And I suppose technically it should also then say, be it resolved that this action has been taken. In reality, most people don't write down that it is a resolution. They just say it's a motion that passed. But a motion that passed would be exactly the same as a resolution. Then you've got these terms of protocols, policies, and procedures. So a protocol and a policy are, I would say, very similar. If you go and Google what the differences are, you can get some information about how somebody thinks they're different. The Google search I did yesterday seemed to believe that policies were more general and vague. So, for example, you could have an investment policy about keeping reserve funds safe and invested in insured deposits. And then you could have a protocol or procedure, which would be specific steps on how the funds would actually be deposited in a bank account, or how the treasurer would move them from one investment to the next, or how the management company would manage a particular account. So a policy is, in most cases, supposed to be a higher level document, but we also see a lot of policies contain all of the detail which we might include in procedures or what we might call a protocol. We also see a lot of those procedures that get stuck into rules and regulations. The difference between a policy or procedure and rules and regulations are that rules and regulations have to be distributed to all owners. and they generally are a interpretation or clarification of the declarations or CC&R's authority that's been granted to the board. So if the CC&Rs say that the board can regulate the use of common area parking, then the board can adopt rules about who can park when and where. And they have to distribute those rules to all of the owners. Under WUCIOA, but not effective for all communities yet, but under WUCIOA, rules have to be distributed to owners in advance of the board adopting them so that the owners have a reasonable opportunity to comment and advise the board about their thoughts on the matter before the board adopts them. It does not mean that the community gets to vote on the rules. It just means that they have an opportunity to make their voices heard before the board adopts the rule. And then once the board adopts the rule, they're going to have to distribute them again to the membership. So the process of adopting a rule is going to end up being someone writes a proposed rule. It gets sent out via the notice provisions to all of the owners, and there has to be a comment period. Now, every board meeting has to have a comment period at the beginning. So if you've sent the rules out 2 weeks in advance of the board meeting, you can use that comment period at the beginning of the board meeting to fulfill the obligation to provide reasonable opportunity to comment. And then at the meeting, the board can discuss and adopt final rules, which may be slightly different than what the rules were that were originally presented. And then after the rules are adopted, they would have to send them out to all the owners and tell the owners when they're effective. Now, policies and procedures and protocol do not have to be sent out to the owners in advance or even at all if they just are relating to procedures. So if you've got an investment policy, for example, that does not have to be mailed out to the owners for their review. It does not have to be mailed to them unless they request it. If the owners request the investment policy, it's clearly a record of the association, and you would need to provide that record when requested within a reasonable period of time. Some more complex associations, especially ones that have in-house employees, may have dozens of policies and procedures that relate to how they transact their business. And the statute is, even at least WUCIOA, specific about not requiring those procedural policies to be distributed to all the owners except on request. So the see if I got anything else in my notes. I think that covers it.
Okay. The next question is, assuming the threat of liens and foreclosure are not the most effective incentive or process for assessment recovery, could reporting delinquencies to credit bureaus be a more motivating, timely, and cost-effective approach? If so, is this service typically provided by association attorneys, or should the board engage a community collection agency once the statutory 2,000 debt threshold is reached?
So I can't speak for what other association attorneys do. I can tell you that we do not report to any collections agencies. And in part because there are a lot of very specific rules related to the reporting and use of those reports. And we don't see that as being particularly advantageous to our clients. Our clients have really powerful collections rights under the statutes. Even if you disagree when the foreclosure option is taken away if the delinquency is under $2,000. The collections agencies that do credit reporting tend to hope that that is going to affect whether a person pays a bill. And it might make a difference for the homeowner's ability to get credit in the future, but you don't have a credit relationship really with your homeowners. You're trying to collect assessments, and we just haven't found it a useful tool. And I'll say for more than 10 years, declined to do it even if an owner has requested. I mean, a association has requested. So the uh, what we typically do is try and work with owners to get onto payment plans and get debts paid rather than to use punitive efforts to try and shame them or punish them or increase the cost. But we certainly recognize that there are owners who don't want to pay, and it takes a court action to get the money from them. The $2,000 threshold is a challenge, but it doesn't mean you can't do other collections activities. It just means you can't do a foreclosure. So RCW 6490-485 is the part of WUCIOA which deals with the collections. It is silent about whether or not you can report to a credit bureau or other reporting agency. And so we don't really know. I can say part of our reason as a law firm not to do it is that we don't know if there's going to be a violation of the Unfair Debt Collections Practice Act. And we also don't want the risk for either our clients or the law firm that someone would file a claim that the reporting to the agency was somehow in error or was defaming or slandering them. And it's just, we don't need that additional risk for ourselves or the client. I will comment that collections agencies have a very different model for how they pursue recovery of unpaid assessments. And we do not recommend collections agencies which work on a commission for an ongoing owner. If you've got a owner who owed money and then they left and you don't have a continuing relationship, then a collections agency may be an appropriate way to balance the cost against the risk of recovery. But if you have an ongoing relationship, we think that you are throwing away money by going to a collections agency because you're not going to recover the fee that you're paying the collections agency back from the owner if they are paying their debt that's owed through that process. And, you know, we used to see a lot of collections agencies involved with some of our clients. I haven't seen as many since probably 8-10 years ago. And I just really want to caution owners about, or excuse me, caution boards about using collections agencies because the number of new laws and procedures required by the statutes for homeowners is very different than what the collections agencies are used to dealing with when they're collecting unpaid medical bills or credit card debt. Diana?
Okay, the next question is, reading the assessment collection and pre-foreclosure statute, it gives time for sending the late notices slash pre-foreclosure notices. However, it seems to assume you only have one late payment. What if you have more than one, as in 3 to 4 months in a row? How do you deal with the dates to send notices? Do I have to send pre-foreclosure notices within 30 days for each month and keep track of the dates for subsequent notices each month?
So I'll offer that it's likely we're going to see some litigation over this because someone can read into the statute some ambiguity. We think that because the statute is fairly specific about the first payment missed and the pre-foreclosure notice, that you're not required to send a new pre-foreclosure notice with every monthly payment that's missed. The statute requires a pre-foreclosure notice within 30 days of the first missed payment, and that's from its due date. And then it requires a second pre-foreclosure notice that has to be sent after 90 days from the first missed payment. So you're trying to make sure that the owner has this at least twice. They have to be no less than 60 days apart from the first notice to the second notice. They have to be mailed to both the unit and the address of record for the owner. And the penalty for not sending this is that you are limited in what you can assess in late fees and administrative fees. So until you have sent the first pre-foreclosure notice, you can only assess one late fee of no more than 5% or $50, whichever is smaller. And you can assess only one $10 administrative fee for sending out the notice. So if you don't send out the first pre-foreclosure notice for 2 months, you don't get 2 months of late fees. You only get that first one. And so there are reasons to try and make sure that you're complying with the notice sent within 30 days. We do recommend sending monthly notices. It's just the monthly notice can be a more traditional, we didn't get your payment and we're, wanting to make sure it's been missed. And here's how you can pay. Here's who you should contact. The pre-foreclosure notice is a different notice, which is much more elaborate than the standard notice. So we would typically send the standard notice plus the pre-foreclosure notice the first time. And then we would expect the association to send pretty much normal delinquency notices for the next 2-3 months, then send the second pre-foreclosure notice along with the routine delinquency notice. And somewhere along the line, you're going to send this off to an attorney who will also send the pre-foreclosure notice. So the legislature is trying to make sure that people understand they could lose their home over a relatively small debt. And that's why they put in these fairly onerous requirements on all associations. Diana?
Okay. The next question is, in general, how do associations handle situations where they have a primary landscape maintenance contractor, but also anticipate separate design or enhancement projects? Are there common approaches, such as preferred provider policies, that allow an association to streamline work with a single contractor? What are the typical risks, benefits, and governance considerations boards should keep in mind when adopting procurement policies that limit or reduce competitive bidding?
So this is far too specific a question for me to give any kind of real answer to. I can give some general advice on procurement of goods and services by associations. Okay. The board has a duty to act reasonably based on objective information and in the best interest of the association as a whole. They are going to be balancing the challenges of getting multiple bids, getting contractors to show up and perform against the benefit which comes from actually performing the goods and services. And it's going to vary by what kind of project and what kind of situation. So, if you've got a leaking pipe, it may not be reasonable to get multiple bids from contractors to come out and fix it. You just call the plumber who will show up and stop the leak. If you were talking about overhauling all of your planter beds to put in new floral displays, I don't know that there's an urgency, but you again are going to be balancing the pros and cons of the efficiency that you can have. And if there's a track record of reasonable prices from a vendor, that might be a more reasonable approach to go. There are some kinds of decisions where the board is bound by the governing documents to get multiple bids. None of the statutes talk about a board's duty to get multiple bids or fixed pricing in advance of having work done. But there are a lot of governing documents for condominiums where if you are dealing with the damage and destruction provision, it will state that you are supposed to get firm bids from 2 contractors before you start restoration work. There are many restrictions in both condo and HOA documents that if you are doing a capital improvement, not a repair, but something new, like adding a gate to the front entrance of your community or adding a swimming pool or new playground equipment or an exercise room, something that wasn't there before, that those capital improvements require approval by a majority or supermajority of the membership. So you want to look to your governing documents to see if there are any restrictions or guidance on the board's authority to engage a contractor or to buy something, and make sure you comply with that. Past that, if you, as a board, believe that you should have procedures in place that require multiple bids for projects in excess of a certain amount of money, then you can certainly adopt policies and procedures as we had discussed before and put those in place to ask the boards as they, in the future, or your employees or managers, to comply with those procedures to make sure that you are meeting your duty of care to the membership. Diana?
Okay, the next question is about an owner choosing to rent their unit to a corporation for their employees to use when they're in town. If the association has rules in place preventing Airbnbs, would this situation fall to Airbnb type contract, or because there is a rental agreement with a specific individual, the board's hands are tied?
So again, this is too specific for us to answer. We would need to actually see the governing documents for the community, and we would probably need to see what the lease agreement was. But in terms of sort of general advice, if you have a prohibition on Airbnb, I don't think a corporate ownership would qualify as an Airbnb because they are not charging individual guests for coming and staying. If the term of the employee's residence was more than 30 days, I don't think there'd be any way of applying a short-term rental prohibition against the use of this. So one of the first things I would probably ask is the corporate ownership and their employees' use of the residence a problem? Because you can certainly enforce noise restrictions, parking restrictions, anything else in terms of problems which a resident is causing, whether they are short-term residents, long-term residents, employees of the owner, etc. And I would want to probably look at addressing those first before I tried to use an Airbnb prohibition as my means of preventing someone, meaning a corporation, from using their unit. Diana?
Okay, the next question is, our board sent out prematurely the list of 2026 meetings. The list only has 6 meetings. One is the budget and one is for the annual meeting. That leaves 4 regular meetings. If we met more frequently, say once a month, what form of notice do we need to give the homeowners?
Okay, so first, I think there may be some confusion between the kinds of meetings, because the budget meeting or budget ratification meeting and the annual meeting should be meetings of the full association, not just the board of directors. And then the board meetings would be just the board, but they have to be open to all owners. But the short answer to the question is you send the notice out exactly as required by the statute of your governing documents, and you would need to send it at least 14 days in advance of the board meeting. If you're going to provide a new schedule, you can certainly do that. Otherwise, you need to provide notice 14 days in advance of each meeting. It's unclear whether the legislature intended that you had to provide a new 14-day notice every meeting to list the agenda items for the meeting. Because it's not possible to schedule a meeting for every third Tuesday of every month and include on that schedule all of the topics which might come up as agenda items for those meetings. So if you're doing something like sending out a new set of rules, I think you need to include in that notice of the meeting where the board is going to discuss and vote on those rules. You can have a standing agenda which will cover a lot of the topics which might come up. So you can have the standing topics, things like appeals to disciplinary action. You can have review of architectural control requests. You can have review of the financials for the association. You can have approval of the minutes of the prior meeting. So it may be that you have items that you can predict and know will occur every meeting, so owners can be informed of those. But if you have something special come up, or you're going to call an extra meeting, the statute does require that you have 14 days notice and provide that to the owners. And, I do want to make sure that people recognize there is an exception for emergency activities that have to take place. We talked a little about that earlier. The legislature wrote in a provision that says that if there was an agenda item that you could not foresee, that you can reduce the notice from 14 days to 7 days. And we're not sure if that means you still have to mail it to all the owners, or if you're allowed to use electronic notice only. And we're going to have uh, a lot of people who are, I'll say, trying to substantially comply. And I think the courts are likely to recognize substantial compliance as being adequate if something is challenged. But we also have a piece of legislation which is very specific and detailed about what is required of the board before they can conduct a meeting and how they're supposed to conduct the meeting. And we just really don't know what kind of punishments the courts will dole out if you don't comply strictly with the letter of that statute. So, Diana?
Okay, the next question is, can we make a rule or otherwise ban a member who has sued the association from serving on the board?
Okay, so my short answer is no. I might be able to say you could set some qualification for board members that might relate to a litigious owner. But I'd also ask, well, what if they won their lawsuit? I don't know that it would be fair to prohibit an owner from serving on the board if they had successfully sued the association. And also, I think that a general principle is that you would want to allow the membership to elect the representative that they want. And so if an owner was found in violation, but the membership want to have that member serve, then I don't think the board can determine a qualification. This relates to an earlier question today. The board can't decide to prohibit them from serving on the board. It might be possible for the membership as a whole to create a qualification for board membership that an owner has not been involved in litigation or maybe not involved in losing litigation against the association. But otherwise, I don't think there's a way to do that.
Okay, the next question, which I think is a question, is what are the statutory obligations on the association when it comes to resale certificates?
Okay. But we weren't sure what the question was, but the resale certificate language is found in the Condominium Act currently for condominiums under section 6434-425, and it is found in WUCIOA under section 640 sub 2. These are checklists of information that has to be provided to every potential purchaser if requested by the owner of the unit. So you only produce a resale certificate if requested by the unit owner. You don't provide them to real estate agents or potential buyers absent a request from the owner. And you're required under WUCIOA to produce that within 10 days. And I think that the Condo Act also says 10 days. Starting in 2028, every homeowner association of every kind and every cooperative will also be required to produce a resale certificate if asked by the owner of the unit. And this is going to be a massive change in how the sale of homes in HOAs is done, because the real estate industry is not used to asking for resale certificates. So we would expect there to be a lot of confusion for existing HOAs, but the requirement is pretty plain. The statute is written just like a checklist. So you can just print it out, and then for every one of the subsections, you provide the information or the document that's been requested. Diana?
Okay, the next question is, if the annual meeting packet clearly states that amendment voting will be extended for up to 11 months and a copy of the ballot is included in the packet, would that satisfy the notice and voting requirements? The packet specifies that voting remains open beyond the meeting date and provides owners with the ballot in advance. Would this be considered acceptable compliance?
So what I would say is that you are effectively voting by mail in this situation. You're not voting at the meeting. You're voting by mail, and you would follow the procedures in the statute for how to vote by mail. All of the statutes have it. In WUCIOA, it's 649455, but that one doesn't take effect until 2028. The only difference between the WUCIOA version and the other three statutes version is WUCIOA requires secret ballots for elections and for amendments to the declaration. So if you are sending out with your annual meeting notice a ballot, you can start collecting them at the board meeting, but you're not really voting at the board or annual meeting. You are voting by mail, and you can collect the ballots for up to 11 months if the board extends the deadline for collecting ballots.
Okay, I believe this is our last submitted question. For an annual meeting, if homeowners cast their votes through a secure online platform, does that count as being present for attendance purposes and towards meeting quorum requirements?
So this is, again, getting a little bit specific because I don't know what the governing documents say about how a quorum is achieved, and I don't know what your particular statute is. As a general rule, the statutes provide that you can use absentee ballots, and those absentee ballots will qualify as being present for a quorum. But I think it's only going to qualify for a quorum for those items which are listed on the ballot. So if you were to send out a ballot for, let's say, the approval of a capital improvement, you're going to add a swimming pool, and you send out an absentee ballot, and it has to be an absentee ballot prepared by the association, because that's what the statute says, and you received a lot of votes via absentee ballot, and those created a quorum. I don't think you could also then count that as a quorum to vote on a different matter, such as waiving the audit for the association. Okay. And it starts to have a lot of specifics where I'd want to review what you're trying to make a decision on and whether or not it's reasonable to count the ballots as making a quorum. Some things like approval of the prior year's annual meeting minutes, I think it might be reasonable to count them towards a quorum, but using that for something like, my example of waiving the audit when that was not on the absentee ballot, I don't think I would want to, I'd feel comfortable doing that. So, I will offer a lot of the energy saving or cost saving methods of voting, like are being done through some different websites. I've seen clients try and use SurveyMonkey for doing elections. A lot of them are not going to meet the kind of verification procedures, which are now included in the statutes, where you have to be able to authenticate the person who's voted and how they voted. And some of them do meet those requirements. So it really will depend on the voting platform you're using. And then in terms of whether or not what you're asking is reasonable, it's going to be very fact specific. Well, I think, Chelsea, we've got time for maybe one or two questions if they've come in the chat.
All right, so first one, do the timeline requirements apply with heat pump ARC requests or ARC requests when there are requests for further information? Does the timeline of 60 days extend, or is that a hard stop?
So what I would recommend is that you deny the application if you are asking for more information. Make it clear that the answer is no today because we don't have enough information, but if you get us this additional information, we will reconsider. I think that the courts have in a couple cases held that if the communication saying we need more information was sent within the 60-day timeline or whatever is in your particular governing documents, that did extend the time for approval. I've certainly had a lot of attorneys try and argue with me that because there wasn't a firm denial within the 30-day or 60-day or 15-day or whatever is in their governing documents, that something was automatically approved. And so I'd like to avoid having that situation by having the association just respond and say, we need more information, so the request is denied today. We have time for one more.
Can things like electric vehicle charging stations be added to rules rather than CC&Rs?
Well, I would say that it depends what you're trying to do with electrical vehicle charging stations. The statute is very clear about what rights owners have to put them within their units or assigned parking spaces. You don't have to have that in either the CC&Rs or rules to comply with it. I'd probably recommend that if you want some conditions that you make a set of rules, there's no need to amend your declaration because what you'd be doing is clarifying the use of the common areas and use of your property in compliance with the statute. If you're talking about trying to create an EV charger for use by all of your owners, that would not require any amendment to the CC&Rs. You would be simply changing use of a common area, which is generally within the authority of the board. And you would probably need to create some kinds of rules so that people knew how they would share the use of the electric vehicle charger. All right, do one more, Chelsea, then we're done.
Okay. Do you recommend that AI recording of board meetings not be used specifically regarding legal discovery issues?
I don't know what you mean regarding legal discovery issues, so I will only answer a question about whether I think AI should be used to record meeting minutes. I'm not a fan of trying to make more and more records of the proceedings. If you're going to record something, I think that the verbatim recording is a record. I think if AI has changed that to something else, like it produces a summary, that is not a record of the association unless the board adopts that as the approved meeting minutes. So a board secretary might want to use AI to prepare a draft of meeting minutes, and I don't see any problem with that occurring as long as the secretary edits them to reflect accurately what actually went on at the meeting. And I can tell you from having seen a number of AI things, they are not always accurate. And they will often make assumptions of things which did not occur. I really often see incorrect interpretations of statutes because the AI will start using what it believes to be the law, but it's using California law or some other state to make a decision instead of exclusively using Washington law. So I guess my answer would be, I don't think an AI printout is a record of the association unless it's adopted by the board to become the meeting minutes, and then it is a record. All right, well, I think we're now over. Thank you everyone for attending, and we'll see you next week.
Thank you.